I'm Dominic Walker, JMW's Inside Man. My guest is Lucy Marlow. Lucy is a senior associate at JMW Solicitors, specialising in intellectual property. So I have found out, and so has the rest of the world as well, that Cuthbert has been freed on good behaviour. This is a dispute between M&S and Aldi over cake, which is, of course, Lucy, my favourite thing to talk about. Presumably there's some sort of confidentiality at play here as well. So what's happened?
Yes, so they finally decided to come to a deal, and the dispute's no longer making its way through the court. They've reached an agreement, but the agreement's confidential. So that's where we are. We've got no more Colin versus Cuthbert, which has been hitting the headlines for a long time. But as you say, Dominic, it's really interesting that they decided to keep the terms of the settlement confidential. And you might be thinking, well, why have they made it confidential? And really, it's because it can be looked at in two different ways. So from Marks and Spencer's perspective, it might be the case that the money or the numbers that they've agreed or the special terms that they've agreed might undervalue or appear to look like their rights aren't as valuable as you think they are, and it might indicate that there are some weaknesses to the claims that they have made. On the other hand, from Aldi's perspective, Aldi might have paid out a considerable sum of money, so Aldi might not want other companies to think that, they've got very deep pockets.
And you mentioned about the future. I mean, at the time, all the talk was about the Colin, the caterpillar cake and the hashtag FreeCuthbert as well. And it really did trend on social media, and people who wouldn't normally talk about intellectual property and even law just got sort of dragged in and intrigued by this. What's your take on that aspect of it all?
I think that Aldi has been very clever because they have launched a marketing campaign where they're very open about the dispute that's happening, and they've made it very funny, so it's very appealing to the public, even though really they're like the bad cops because they're the infringing party. But they've gone on a campaign that's really, really quite entertaining, and it's raised the profile of the dispute. So things like FreeCuthbert and videos where Cuthbert's in the background with a policeman, and he's in handcuffs. It's very entertaining. But what's interesting is that whilst on the merits alone, it might be the case that Marks and Spencer have, very good grounds for dispute. It might have been the case that such a high-profile marketing campaign has made it so that for commercial reasons, Marks and Spencer have been more willing to do a deal rather than purely on a legal analysis. And
the marketing, the PR, rumbles on because we're told to look out for Cuthy B in the springtime.
Exactly, and that's almost like a nod to, Cuthbert's not over. Let's see what's happened. And it's intriguing because naturally you're wondering, well, what will this caterpillar now look like? Will it be a caterpillar? Will it look similar to Marks and Spencer's? You'd assume that it wouldn't, because otherwise, Marks and Spencer's would be able to rely upon their rights again, and they would want to complain that we've got another copycat passing off case. The very fact that Aldi are saying that, there is going to be another product, to me indicates that the terms of settlement that have been reached are quite detailed and have quite neatly marked out exactly what it is that Aldi can and cannot do, because these two do not want to see themselves in court again arguing over similar facts.
And you mentioned about the agreement might be quite detailed. I mean, behind every PR campaign, and it has been interesting to watch from that perspective, that there will be, as you say, sort of detailed, serious documents. How can you help in those sorts of disputes, Lucy?
So obviously when they reach a deal, they would have reached an agreement. So that agreement ideally should be properly drafted up with consideration as to all of the interests that you want to be protected. And typically within, for example, a trademark infringement dispute, you might have a coexistence agreement put in place. And that's very helpful because it clearly marks out how each entity can operate. Because if you're both in the same industry dealing with similar products or you've got a similar name, you need to be clear as to where the boundaries lie to ensure that you don't infringe on each other's rights, step on each other's toes in the future. It's like an insurance policy.
Excellent. Lucy, thank you so much for your insight, and all this talk of cake has made me feel hungry, I'm afraid. If you'd like to contact Lucy and the intellectual property team, you can email insideman@jmw.co.uk or call 0161 82 81 999. I'm Dominic Walker, JMW's Inside Man.